Morgan Hill, here known as a CAC. In the past, we have, speaking on behalf again of the CAC, we have come to the board several times requesting things such as search of a superintendent. The process we felt was not adequate. Charter schools, we felt that we needed them in the district. More Latinos in education, teachers, more Latinos in principalships and things of that nature. And we constantly get escorted to the door. But our appeal today is a little bit different because this is not a request as in the past where we were outvoted, usually 4-3. This is not a plea where we were outvoted in the past. This is different. This is a demand. The demand is that this district must change from an at-large to a by-district voting system. Now, understand one thing. Again, you are not looking at myself and the group that I represent, the CAC, as a ragtag group of disgruntled Latinos in the community. What you are looking at is, and all of you are familiar with this because I've heard this word many times tonight, you are looking at the state legislature has passed the CVRA for a district like Morgan Hill. And that district must be in compliance with the law. And right now, the district is not in compliance with the CVRA. One of the key elements of the CVRA is racially polarized voting, which dilutes the vote of a protected class. We strongly feel, after counseling with the people that are supporting us on this issue, that Morgan Hill is in non-compliance of the law. The district is in non-compliance. So, at the moment, let the record show there is no litigation involved. However, it is up to you, the board, to, in our humble opinion, approve the change under the CVRA to a by-district election. Because under the CVRA, you have the right to change it. All you have to do is submit a waiver to the state of California, and they will grant it to you. Right now, 79 waivers have been requested, and all 79 have been given. It is up to you to do that. And I will close by saying the following. What's that noise? Your time is up. Man, that 2 minutes went pretty fast. 3 minutes. I'm going to close in and saying this. That the CVRA is something that you must accept, or you are not going to be challenging us. You are, if you do not vote on it and request a waiver from the state, you're not going to be challenging me or some of our other members. You're going to be challenging the courts. Okay, you're going to be challenging the state legislature. Okay, not a state legislature. Thank you. And that is a challenge that you're going to have. Thank you, Mr. Benevento. Thank you. Thank you. Okay.
Next part, Benavides. You get 3 minutes.
Good evening, board members. My name is Armando Benavides. I am an attorney, and I'm really excited that a resolution is before you for consideration. I'm asking each of you to support the resolution to begin the process that hopefully will lead to by-district elections. By-district elections will allow for an election of a board that will better reflect the various subgroups that form the fabric of our community. I have examined election records from many years past and did not come across any candidate elected from South San Jose, where a large number of voters live and where two of our schools are located. The South San Jose area serves as a feeder area for our high schools. And I also did not find anyone having been elected from San Martin, where we also have a large number of constituents in elementary school there. And of course, we have the largest stakeholders in the district, Latino parents and students that would benefit greatly from this resolution by having elected representatives that would reflect its community of interest. There are many criteria that will be applied to draw the map boundaries for the proposed election district. My understanding is that a demographer has already been retained, and that demographer is going to look at the criteria that is made part of the resolution. And the resolution basically covers all the criteria that is required by law to be applied. There will be many benefits to go by district election to be easier to run a campaign. It's really hard to target so many voters, the whole entire from San Martin all the way to South San Jose, east and west of Morgan Hill. We would have greater voter engagement where parents would feel engaged. The hardest thing for me was when I was campaigning, I would call any voters in South San Jose and they would tell me, why should I vote? Nobody comes out here, nobody cares about us. But there's also a divide between the urban over there and the city. So there's a lot of good benefits that would come from going by district. I urge you to pass a resolution, and I look forward to looking at the map boundaries that are prepared by the demographers, so we could have further campaign how we could improve the governance of our district to make it more reflective of all the stakeholders in our district. Thank you.
Thank you, Mr. Benavides. And your final speaker, my old friend, Mr. Tony Sines.
Good evening, board members, superintendent. I'll make it brief. I agree with my counterparts here. What I'd like to do is plead that we work together, make this a smooth transition. Working together will only benefit our community, and the end result is better representation on the board and doing more things within our community, whether it's in our high school, grade school, or junior high. I think these are the decisions you'll make, and we can save money in the long run and work together, keeping it out of the courts. I think that would be more beneficial to all our community to keep it here in town. So, thank you for your moment, and good evening.
Thank you, Tony. Are there any other speakers?
I'm sorry that the civics students had to leave, because this, of all the agenda items, is really a civics lesson when it comes to the actions on the board agenda tonight. Interesting analysis and history involved here, and really with pretty important effects that will be more than just the school district, depending on the outcome, because this act doesn't just apply to schools. It applies to other municipalities, the city governments, county governments, and such. So the California Voting Rights Act, mentioned as CVRA, was enacted in 2003, so it's been quite a while, 12 years. The law is designed to promote political representation of diverse communities, and Morgan Hill is certainly one of those diverse communities. It tries to reach the goal by advocating a change of at-large elections, as the speakers talked about, in which all voters are given jurisdiction, and in our case, the school district is the jurisdiction for each and every seat on the governing board. And so the proposal is to change how those elections occur. The law prompted an election process change and changes for representative or trustee areas. The elections to instead be by the entire district and trustees by the entire district. It would be to subdivide the school district and in city cases or municipalities or counties to specific regions of the jurisdiction. The premise is that by doing so, the process gives minority voters a better chance of electing candidates of their choice. Once the election area designations are changed, candidates must live in the area they are competing to represent, and they are elected only by the voters in that area. rather than the voters throughout the district. So as it is now, trustee is elected by all the voters in the general Morgan Hill School District, which, by the way, is not just Morgan Hill. It's 300 square miles. It goes from Patterson in the Central Valley to Los Gatos to Gilroy and into San Jose up to Grinnell and beyond. The CVRA is based on the assumption that at-large elections often put voters who are members of a race, color, or language minority group, specific to the law, that's language specific to the law, at a political disadvantage, making it difficult or extremely difficult for the minority group to elect candidates that they prefer because they are consistently outvoted by voters elsewhere in the jurisdiction. That's the premise of the law. The district's governing board reviewed the option for the election process. This district reviewed the option for the election process changes back in 2009, before I or anybody here sitting at this dais was even in the district. And it wasn't a community group or a community advocate that brought this to the attention. It was the Santa Clara County Office of Education that actually created a resolution to support districts in the change should they go to change by their own action. At the meeting here in this district, on October 13, 2009, the Morgan Hill School Board members agreed that trustee areas would not work well for Morgan Hill. This was the outcome of that meeting. The minutes stated that trustees, quote, trustees take into consideration what is best for all students in the district when making decisions. Having trustee areas might also weaken the pool of candidates by limiting election to geographic areas. That is, word for word, what the minutes read from that meeting. We have been contacted by community members who respectfully request that the board once again review the demographics of the district and give staff the opportunity to bring back map options for the board to look at. And should we determine that redesignation by trustee area is the way to go, take action on that. That's what they're asking. I am recommending that the board discuss steps toward a change in the election process by first allowing us to direct a demographer to create trustee area maps. And as part of this direction, we ask the board to consider the criteria that it wants the demographer to use when drawing these maps. And the board, and in public view, we have the sample criteria that is currently used for this. If this is the board's interest, a resolution is before them. And the criteria, as I mentioned, is also there and can be amended by the board discussion if discussed. If we do move forward, we would like to agendize the consideration for map review in April. We have asked an advisor, who also is an attorney, Harold Freeman, who has had great experiences with other district and municipalities, advising them on the process, should this board determine that this is the process that it wants to go to. And Harold Freeman is here, and he has a vast amount of experience with districts considering CVRA. And I would ask, I hope he's here, Harold to, oh, there he is right there. I'm looking over. I'm so used to looking for the teacher out there. Harold, if you don't mind, please step to the podium and maybe a couple introductory remarks, and then I know board trustees have some questions.
Thank you. I appreciate it. Well, I think the stage is set fairly well by the comments that you've had and the comments from your superintendent about what's in front of you. Just to clarify, the California Voting Rights Act does not state that having the trustee area elections necessarily means that there's a non-discriminatory practice involved, nor does it state necessarily that having at-large elections to the whole district is itself discriminatory. You have to look at the statistics of the facts in each circumstance. So really what's before you is the opportunity to move forward with developing these maps to take a look at what the trustee areas might look like. It would not be a commitment at this point to actually have the trustee area elections, but rather to get public input to see how that trustee area might be laid out. And the other thing I'd add is that the role of the demographer in this is incredibly important, it's incredibly critical. The demographer with whom we've been working and who's been looking at your situation, Doug Johnson, has been through this in multiple municipalities, school districts, special districts around the state. what he would do is take the census data that's available every 10 years, most recently in 2010, break that census data down and really use it as a way of configuring a proposal of what to look at. The purpose of the resolution tonight is really to give direction to the demographer and to make a record of how you're going about this with criteria. And the way the resolution was set up, it's really a checklist you can choose from. The criteria that you see accompanying in the exhibit to the resolution are really standard criteria. They've been slightly tailored for your circumstances. I did want to point out that the first 3 of those criteria are legally required. So when you go down that checklist, the first 3 are straight out of statute. They're really not a choice. We wanted to include them for your information. The rest of the criteria are really where you have a little more flexibility in giving direction. But I know there may be questions, and I think that probably hopefully sets the stage adequately for the discussion.
So, trustees, while we have our expert panel, do we have any questions?
Yes, Mr. Freeman, I wonder if you could tell us what the result has been in those districts that have chosen to go in this direction of moving from at large to a district configuration in terms of the change, in terms of the election results. Do you have any information about that as to whether this has been effective to meet the local legislation?
Yeah, I can only give you anecdotal evidence. I'm not aware anybody has compiled statewide data on this, but anecdotally, there are some districts that historically had underrepresented groups. Frequently in the state, it's Latino groups that are underrepresented that have, after change, seen Latinos elected to positions that they've not held office historically in that area. The majority of the districts we work with, school districts in particular, we have not seen a significant change. So there's anecdotally, we can point to a school district here, a hospital district here, a city here. Often it doesn't lead to a change, but you've removed the barrier to the voting. So you're complying with the California Voting Rights Act, which is less concerned with what the result of the election is and more with the ability to at least have the potential of a greater safety to represent the group.
Questions?
So, with regards to the timeline of the process, moving forward, if Workso chose to go this route, how soon would it?
Sure, but let me talk you through the timeline just briefly. So the law requires that you have a total of somewhere between 2 and 3 hearings, and I say that as kind of an odd statement, somewhere between 2 and 3. There have to be a grand total of 3 hearings. There has to be 1 hearing that occurs in front of the county committee on a school district organization, and we're actually trying to get a clarification because the law changed in 2014 on the number of hearings from the legislator's office who actually made the change to confirm whether you have to have 3 hearings, followed by a hearing by the county committee, or you have 2 hearings, followed by the county committee. Those hearings all take place after you actually have map proposals in front of you, which you don't at this point. So this is sort of a bonus hearing tonight. So conservatively, what that may mean is you have to have 3 hearings, which could occur April, May, June, and moving forward to your next 3 board meetings. When that process is done, it goes to the county committee on school district organization. They'll have another public hearing. And when that's completed, the other thing that will be happening that the board will get to decide on is whether you want to go out to have an election or go to the California Department of Education and get a waiver of having an election on this issue. If a waiver is granted, the county committee decision is the final decision. They'll review your map. If they agree with your recommendation, you're done. It gets implemented. The implementation is for the next election happening at least 120 days after the county committee's final action on that, assuming there isn't an election, or after an election, assuming there is an election. So just realistically putting that together, you're probably talking about sometime this next fall. If you start this process up now, sometime this next fall, you'd be to the point where the final action has been taken, assuming you're not going out to the voters. If this was to be an election, potentially we'd be going forward to an election in November for the voters to decide one way or the other on the proposal. In either event, by the end of the calendar year, we expect the process would be done. And what that would affect for the next school board election is your next open election is 2016. I can do the math quickly in November of 2016. So under any of those time frames, there should be adequate time that this would be implemented well in advance of the 2016 board election.
So with that being said, if the district chose, how many districts have gone challenged
No public agency in California has yet succeeded in defending one of these lawsuits. So every lawsuit is either settled or it's been found against the public agency, school district, city, or special district.
Trustees, additional questions?
I have,
Trustee Bourgeois.
thank you. I have, 4, if I may. What's to prevent other ethnic groups from coming forward and doing the same thing?
Any underrepresented class that lives in the district would have the opportunity to challenge the process. One of the things that will be happening is the demographer would not just be taking into account Latino population. So the two significant minority populations in Morgan Hill, as the demographer's already identified, are Asian Pacific Islander and Latino. And in formulating the proposal for what the different trustee areas would be, it would take into account each of those populations. So it's not just geared towards the one population, but any member of an underrepresented class could file a lawsuit, could bring a challenge, and in fact, any member of any class could bring the lawsuit contending that underrepresented populations are not being given the fair opportunity to be elected.
So are trustees only responsible for their districts exclusively? And would that lead into, I'm not saying that would happen here, but some type of quid pro quo atmosphere, if you do this for me, I'll do that for you, and kind of skew the at-large, as comparison to the at-large, skew how things are done.
What I can say again is more anecdotal. The school districts we work with, that has not transpired. Generally speaking, any trustee who is elected to a school board represents the entire district. Every vote they take affects every student in the district from their particular area, but votes don't occur, for example, by, let's go around the room and see which area is affected. And what you see, and I'll use as an example, is Santa Clara County Office of Education has had trustee areas for years. And you will see sometimes where a particular member of the County Board of Education is perhaps more passionate about a particular issue from within their district. Every vote taken is district-wide. There's always the possibility of a kind of stratification where people break down by the districts and it stops being a district-wide approach to things. But in a lot of ways, that's really an issue of governance, of good governance, and a critical understanding that when elected to the school board, you still represent the entire district. Your decisions still affect the entire district. But it is sometimes a subject of debate whether it could lead to this kind of stratified voting where people are only voting for the interest of a particular area.
Thank you, Mr. Freeman. I have one.
Let's have some of the other members. We'll come back to you. Trustee Wolf had a question. We'll come back to you.
I had a question. I think it's 27% of the voters in our school district.
Yeah, that's a rounding off, but 27% of the adult.
This is a point of information for everybody. The previous 2 years, we had 2 Hispanic members on our board, which constituted 28%. But the other thing I want to point out, after the demographics are done, and let's say we come up with 7 areas, and we have the election, and no or one Hispanic is reelected or elected to the board, does the demographer go back to the drawing board, or what takes place?
Again, the process is the key. The result is in some ways less the key. So if you've gone through the process and you've opened the door to the voters the way that the Voting Rights Act intends, the fact that Latinos are or not elected, or Asian Pacific Islanders are elected or not elected, isn't determinative of whether you're complying with the law. It's have you open that door to allow for that opportunity.
There's a process.
It is a process. And I should note as well that under the Voting Rights Act, once you move to this process, you revisit the trustee areas, you re-examine them every decade. So every time new census data comes out, you receive that data usually the calendar year after the census is complete. So 2020 would be the census, 2021 you get the data. By March of 2022, you're supposed to have revisited if there's any need to revamp those lines. But that's, again, not based on who's been elected. That's just based on how populations have changed.
Trustee Reeves, any questions?
No.
Mr. Bojoli?
So, if the voters, after the 3 hearings, decide to bring this forward to the 2016 election and vote on it to oppose redistricting, and they vote in favor of continuing the at-large, what happens then, Mr. Freeman?
So with the election, what can happen, assuming that the district does not seek California Department of Education waiver from the state board and you move forward with an election, and I have to note anecdotally or incidentally to that every school district that has sought the waiver has received it. The state board hasn't denied any of them yet. They've approved about 100 of them at this point. If you move forward with the election, you don't go that route, and the electorate turns down moving to the trustee area election, at that point in time, a lawsuit can still be filed. It would be filed against the school district, and it would still contend that you're not in compliance with the California Voting Rights Act. If a judge were to concur with that, if the district litigated that all the way through and a judge concurred, you could be ordered to then implement a trustee area election, even with the voters having rejected it. And the rationale behind that act, again, sort of evolved from the Federal Voting Rights Act, where in the South and a certain number of segregated states, the question of whether to desegregate kept getting put to the voters kept voting it down. And ultimately, the courts had to intervene and say, regardless of what the voters are saying, you have to come up with a system that works. So merely having the election does not necessarily mean you escape potential liability.
So the only way to change it, if the voters wanted to change it, would be to try and change the law.
That, generally speaking, that's correct.
Thank you, Mr. Freeman.
Okay, hold on. The chair will recognize. Okay,
So Gino brought up a couple questions regarding elections, and you mentioned earlier if the community went out for elections to see whether we wanted to move forward with the cost of the election is incurred by the district, correct?
Yes.
Ballpark.
You know, it's hard to say. That would take some research to figure out what the voting pool, how many ballots would have to get printed and whatnot. Generally speaking, you're certainly talking tens of thousands of dollars for that type of election. It's probably not 6 figures. You're probably talking, anywhere from 10 to 50,000, depending on the size of the electorate. But we'd have to do some research on it.
To have an election.
Right.
Now, if the district chose not to go this route and vote for
Again, hard to say, but what we can tell you is that under the California Voting Rights Act, you'd obviously be paying for your own attorney's time. If you are not successful in the litigation, you also pay for the other side's attorney's time. So if you do not succeed, you pay for the attorneys on both sides. And the attorneys that are acting as the plaintiffs in that matter can generally seek a multiplier of their fee based on the public interest that's involved under California law. So you're talking about potential fees of $700, $800 an hour up, perhaps as much as $1,000 an hour. The cities that have gone all the way through litigation, the fee awards have ranged all over the place. There's 3 awards that are over $1 million. That's just in attorney's fees, just to the successful plaintiffs. That doesn't include what the agencies pay to defend it. For those agencies that have settled lawsuits after they've been filed, generally the fees have been over $100,000. If you average them out, looking at a lot of the cases, they run generally between about $100,000 and $500,000, depending how quickly the lawsuit settles. So you're very quickly talking about very substantial amounts of money. And again, that doesn't include your own attorney's fees. The largest award in the state was over $3 million.
Trustee Reeves.
I want to make sure I'm understanding. It's my understanding that we as a board can make a decision to move forward with the demographer to begin looking at what the maps might look like. And we can move through that process. And we as a board can decide whether or not to have areas or not have areas. An election is not required to determine the area, trustee areas, correct?
Up front, you would be the one proposing this is what the map
Okay.
would look like. And then it's a question of whether you put that map to the voters or you go to the Department of Education and get the waiver.
Okay, so the waiver is to just move forward to an at-large election for candidates, not areas.
No, it's actually what the waiver would be to avoid having the cost and the time of the local election. So if you receive that waiver, what you'd be then doing is proposing this map, if the map is approved by the board, and submitting that to the county committee, and the county committee would be determining yay or nay after that map. And then once that's determined, you are locked in 120 days after that. It's officially in place, and the next election will be based on those trustee areas.
Okay, all right, I understand.
Trustee Director.
Mr. Freeman, let's say after the district proposes a particular map and community members feel that the map itself is not helpful in terms of what they're seeking. Do they have the right, and if they do, to challenge that map and to substitute or suggest a different map?
The way the process works is you'll get the public input if you go through the hearing process. So there's an opportunity to sort of vet the different ideas, people to give proposals. If ultimately you make a decision that somebody feels is not compliant with the law still, it would go to the county committee. Those individuals would have an opportunity to appeal essentially to the county committee to go appear in front of the county committee and make their case. If the county committee says no to your particular map, it comes back to you, you get the chance to go back to the drawing board. Typically, county committees will generally, if there's a reason, basis for the map, will support that. County committee would approve that. At that point in time, a legal challenge would still be filed saying you didn't accomplish the end result.
Then a follow-up question would be, is it possible, or do you know of situations where there's been a, let's say, an opportunity for the community to comment on the map before it goes to the county?
Well, again, the opportunity to comment really comes in your public hearings. So the notion is that you would come up with usually a series of maps, so you have some different options. Vet them. School districts will typically, or other municipalities, put them on their website, make them generally available so people can weigh in. And again, the law was amended to make clear you can't just have one hearing, you have to have a series of hearings to maximize public input. Once you have that map and that map is in place, the general, if the call is gone, now you work with a qualified demographer, you're likely to be able to withstand scrutiny if there is a legal review later, as long as you've gone through the process.
Thank you, Mr. Freeman.
Any other questions? So then I have several, if I may. So the trustee area boundaries are determined pretty much through the demographer in the school district. Is that correct?
Yes.
Okay. And are there any constraints informing these boundaries at all?
Yeah, there's some legal restrictions. The primary one is both under the Education Code and the California Voting Rights Act. You have to have the districts that are created, the trustee areas that are created, generally be equal in population to one another. There's some slight variations on that are allowable, but the notion is that you're not supposed to have one trustee area with more clout, if you will, than another. So they have generally equal populations. You are supposed to attempt to keep them compact in the sense that they should be contiguous and preferably not broken into different pieces around the district, which makes elections generally difficult, is another legal requirement. Obviously, a legal requirement around them is you have to engage in balancing of the ethnic populations, the underrepresented populations that you're talking about as well. And then the last one, and this is kind of a confusing concept, you're not supposed to engage in gerrymandering, which it's actually a legal term, because when they talk about gerrymandering as a legal term, what that means is that you're not creating districts primarily intended to result in the election of a particular political party, as opposed to a particular ethnic group. And the U.S. Supreme Court has reviewed that distinction and made clear if you've got a legitimate reason to shaping a particular territory, voting area in a particular way, for example, to give more voice to underrepresented people, that is not gerrymandering, that is legal. If you're doing it for a nefarious purpose, for an unlawful purpose, then that's considered gerrymandering.
Can the number of trustees for the board be adjusted downward, say from 7 to 5, or upward from 7 to 9 or 11?
Yeah, you can adjust downward to 5, and generally speaking, for school districts, you can have a 5-member board or a 7-member board, and those are the extent of your options without special legislation. So a 7-member board could either, as part of this process or as a separate process, look at moving to a 5-member board, just as a 5-member board, look at moving to a 7-member board.
And since we have 7 members on our board and we are elected 3 and 4 in alternating elections, or every 2 years, what happens to those that are not up, or those that are up for election versus those that are not up for election in 2016?
Sure. One of the provisions of California law is that if the move to the trustee area is made, no incumbent loses their seat as a result of that. So every incumbent gets to carry out their term. There's all sorts of you can make very complex diagrams about all the possibilities of what happens next. But generally speaking, if somebody is up for election in 2016, they will be up for election in 2016 in their trustee area, in the trustee area they're located in. If they were up in 2018, they will be up in 2018. So it essentially phases in the trustee areas. What gets very complicated is if you form a boundary that has 2 or more trustees living in one area. Because what that would mean is when the person is up in 2016, if they live in the boundary of the other person, you have to determine, are they running for that trustee seat? And then when the person's up in 2018, are they out of luck, or vice versa? Mm-hmm. And so there's a lot of complications around that. For that reason, the law specifically provides that you can consider where your existing incumbents live now to try to make sure that they are each in their own district to start with, if possible, if that can be accomplished consistent with the goals of the California Voting Rights Act. So generally speaking, what municipalities do is try to ensure they don't have 2 trustees in one area to avoid these complications.
Well, the Santa Clara Unified School District has that very type of situation where they do have trustee areas where there are multiple representatives and multiple trustees in one district. So is that an exception to the rule, or is that something that's, how would we handle that? That we have 3 trustees that live within less than half a mile of each other.
Well, as far as the not looking at Santa Clara, because I'm not sure of their specific situation, but if you look at your district, you can have trustees that live a few blocks from each other. And, what demographers like to say is they can actually make the lines so fine in creating these different trustee areas. They can follow fence lines. So you can have 2 neighbors that are immediately next to each other that are in 2 different districts. Sometimes it's not possible, but it's almost always possible. And that's one of the criteria that's included in the resolution you're looking at tonight. If you did end up with 2 in one territory because of the way that you formed it, there are some provisions in the code that talk about drawing by lots. But I think what that really contemplates is you have 2 people up for election in the same year, as opposed to finishing after incumbency. We'd have to kind of test it out, but what it would probably mean is if you have somebody who's there through 16 and somebody who's there through 18 in the same territory, the person who's there through 16 would be there through 16 and then would lose their seat because they've carried out their full term, and there's already another trustee living in that area. But frankly, I've yet to see one come up that way, so we've yet to have to put that to the test. We'd have to dig a little deeper.
And, excuse me, should the trustee areas, by definition, have a school within them? I mean, we have some pretty vast areas here. Does the school have to be within the district, and should there perhaps be more than one school in the district?
It doesn't. There's no criteria that requires that. We included in the criteria, and it's pretty typically included in what you see with your resolution, consideration as to attendance areas, as to where the schools are. But that is not a defining characteristic. And in fact, in some districts it can't be, because there are districts that have trustee area elections that only have 3 or 4 schools that have 5 board members, for example.
And I guess, trustee areas being changed. Now, for example, if indeed 7 trustee areas were carved out to accommodate that, they were indicating that the for trustee area. from the present sitting board. What happens if somebody says, "Well, I want to change that trustee area now"? Can that be? How is that handled once the census comes out every 10 years? Or, I mean, if somebody wants to challenge this, it could be a challenge every 2 years.
Right. There's two ways laid out in the code that somebody can go about this. One is the one we talked about, you just mentioned, which is every 10 years, the boundaries are revisited, they're looked at again. The other possibility is that already in the code, even if we weren't having the discussion tonight, people can petition the county committee and ask the county committee to make a change. And if that is the route that they go, they would actually be potentially asking the county committee, we want you to draw those maps. We want you to decide this for yourself. It takes a certain number, you have to get a certain number of people to sign a petition based on the number of registered voters you have. I have not yet seen one of those. I've been at this for 21 years. Maybe it's happened somewhere in the state, but I haven't seen it. Because generally the county committee can just turn that down. And generally speaking, county committees would rather leave it up to the school districts themselves to decide what they want to do. So those are the two sort of procedural vehicles that are out there to accomplish.
Thank you very much. I have no further questions.
I think I go forward because of, I don't want to assume that you're seeing this all the same way. So I don't.
Okay, so we have some questions in front of us. So before we move to a motion, how about we entertain a little discussion here? Trustee Gerard, a second.
Well, I think it is good that we have a discussion about this because many people would be confused by what this would mean, and I think Trustee Borgioli perhaps might have raised the question as to whether someone who is elected in one particular district would therefore represent only that district, and it's very clear that that person would actually still represent the entire district. In fact, even though someone were running for or elected to that district, they could actually campaign throughout the entire district. They could see, and they should, I think, see the entire constituency, from San Martin up to South San Jose, as their voters, as their constituents, actually. So I think that's one of the things that people really need to get clear about. I think it's very clear to me. When I first heard about this, it was my fear that perhaps people might be drawn to thinking on a district by district basis or even a school by school basis. And the more I talked with community members, the more I did research on it, the more that I looked at other districts around California, and indeed in Silicon Valley who have gone to this and who I've talked to, other elected officials, that isn't a problem typically. This is really something that has to do with, do we want to give access, possibility to a larger scope of people than we have currently on the board.
Thank you, David. Trustee Padilla.
Well, with all that Mr. Privilege provided, financial costs and implications, whether this is a good idea or a bad idea, it's the law. So I don't see how we can not entertain this resolution. Anything less would be non.
So let me share with you some history, which Mr. Freeman alluded to. One of the initial cases was the city of Modesto. The city of Modesto's attorney's fees, their own school district of the city of Modesto's attorney's fees was $1.7 million. They lost, and the penalty they incurred was the opposition's fees, which was an additional $3 million. So that was a $4.7 million legal defeat. That's a pretty big axe. So if that doesn't influence your thinking, perhaps it should. We have, okay, I'm sorry.
Of course, there's financial, and fiduciary concerns, but I think the focus of the discussion is this the, for lack of a better word, the right thing to do, and to proceed and begin the study and get the demographer working on what the areas might look like. But the public hearings will also give us an opportunity to inform the public about the potential and the limitation of trustee areas, and that's where we'll get our interchange of ideas and we'll understand what the public is thinking further on it. But I think we should proceed forward.
Thank you. Trustee Rizzuto.
Yes, I just don't think we have a choice. I think spending $250,000 to $1 million to try and beat this when we could use that money for kids, I think for me that's hard to swallow, whether I agree or disagree. So I look at this as until the law is changed, we just have no choice except to move forward.
Okay, so let me continue to read from the rationale. It says, to prepare options and as part of the consideration for such a change, a resolution is before us, which would establish criteria to guide the demographer who will prepare maps, potential election areas for the board and the public's review and discussion. You've all had copies of the resolution, and you've had copies of the addendum to the resolution, Exhibit A, with criteria to guide the establishment of trustee areas. Do you have any questions or concerns or comments that you'd like to add to or delete from the resolution and the attachment? Okay, in that case, I have to call for a vote. Do I have a motion?
So moved.
Trustee Gerard, do I have a second?
Second.
Trustee Rebush. I'm sorry, okay. Trustee Gerard made the motion, and Trustee Rebush made the second. Sorry. Okay. We have a motion, we have a second. Do we have any other discussion before we proceed with the vote? No.
It's a resolution, so if it's unanimous, then we have unanimous.
Do we need to read the resolution?
We know where to find it.
Do I need to read the resolution?
Well, you might want to. You've all read the resolution, but the other.
All right, I'll read the resolution.
One person just read it.
Okay. This is a resolution establishing criteria for developing trustee area boundaries. Whereas the Board of Trustees or the governing board of the Morgan Hill Unified School District was elected under an at-large election system where trustees were elected by voters of the entire district. And whereas the governing board is considering a change to by-trustee area elections, where each trustee must reside within the designated trustee area boundary and is elected only by the voters of that trustee area. And whereas the Federal Voting Rights Act, 42 U.C., Section 1973, prohibits the use of any voting qualifications or prerequisites to voting or standard practice or procedure in a manner which results in the denial or abridgment of the right of any citizen of the United States to vote on account of race or color. And whereas federal law and the Equal Protection Clause require that each trustee area be equal in population generally, however, deviations, parentheses, less than 5%, greater than or less than the ideal, for a total of 10% deviation, are presumptively constitutional under the Equal Protection Clause where required to meet an official criteria. And whereas the governing board has instructed its demographer and district staff to develop draft maps to identify potential trustee areas to be considered and that fully comply with the legal requirements. And whereas the governing board wishes to provide official criteria for any needed deviations from the general rule of equal population. And whereas the draft maps will be used by the governing board to study the possible change to quote-unquote by-trustee area elections and to inform and solicit input from the public. Therefore, be it resolved that the governing board of the district hereby adopts the criterion identified in the attached Exhibit A to guide the demographer and staff in the development of draft maps and in relation to any necessary deviations as described above. And be it further resolved that the superintendent or his designee shall be authorized to modify these general criteria so long as such changes are consistent with all requirements of law. And be it further resolved that the superintendent or his designee shall be authorized to take any additional acts needed to effectuate the purpose and intent of this resolution. That is the resolution. I won't bother reading the attachments. We have a motion. We have a second. Call for the vote. All in favor indicate by saying aye. Aye. Are there any opposed? Miguel, how would you like to vote?
Yeah, I say aye.
you. Miguel says aye, got that. So we have it at 6-0, no opposed. One absent.